Chapter 5 of the Law of Journalism and Mass Communications. We're dealing again with defenses and privileges for libel suits. And we are all the way down to other defenses. We're going to be covering single publication rule and the libel-proof plaintiff, as well as additional defense considerations. The single publication rule applies where something has been previously published and archived, and then that piece has been reprinted and republished or reissued. You can only get sued one time for that publication. Reprinting it from an archive does not count as a new publishing event. It's akin to with criminal lawsuits, double jeopardy, where you can't be tried criminally for the same crime twice. Same type of idea here. You can't be sued twice for one single action. Then there's the concept of the libel-proof plaintiff. As a defense, it's kind of unusual. You're looking at the character of the plaintiff who's bringing the lawsuit and saying that their reputation is so badly damaged already, there's no way that they can collect damages. There's no further damage that can be done. So, the example that's given in the text is that somebody is labeled a thief, a child molester, tax evader, and a kidnapper. The first three are true. The last one is false. But it doesn't matter. It's piling on. Because the other three are true, the person's reputation is completely devalued. So, single publication is a matter of process, and libel-proof plaintiff, that's a matter of looking at the person. All right, speaking of process, the additional defense considerations, I'm going to briefly highlight some of the considerations. So I want you to think back to the Shoots and Lawyers that we did. Summary judgment, remember that's further along in the process, taking a look at all the facts. There could be no dispute between the two parties, and the defendant still wins as a matter of law. Going back to the checklist, going back to the elements, the plaintiff isn't able to meet the burden of proof, having enough facts to back up the claims that are made. A motion to dismiss for actual malice, where somebody is knowingly making a statement that is false or recklessly making a statement that is false. Again, that goes towards sufficient evidence. Remember, with these two defenses, this is a matter of timing. So a motion to dismiss can happen right from the outset of the case, and that can travel forward through the process as you're going through the later stages of the trial process. Summary judgment happens a little bit later. Now remember, we talked about this earlier. Some jurisdictions are a little quirky, and they may require a plaintiff to meet these standards early on in the case, making it harder for the plaintiff to prove the case and move forward. Jurisdiction, the authors bring this in, and the argument with this defense is that the court doesn't have the authority, doesn't have the power to hear the case, and the type of jurisdiction that the authors are focusing on is jurisdiction over the person. That's a matter of geography. Where did the actions happen? Where are the parties' residents? And in today's day and age, with the internet, a lot of statements are made online, so the boundaries of jurisdiction kind of fall away. With the internet, it's opened up those borders and made it possible many additional courts to get jurisdiction over the parties. Statute of limitations is what I call you snooze, you lose. You have a limited window of opportunity to file a lawsuit as a plaintiff. Depending on the jurisdiction, those time periods are going to be different. It could be 1 year, it could be 2 years, it could be 3 years. There is a map in the textbook, and I actually have it on the next slide, that you can take a look at to see which states have which time period. Ohio is a 1 year time period for statute of limitations. File the lawsuit within 1 year of the injury of the statement being made, or else you can't use that cause of action. You can't use libel as a cause of action. Retractions. Retractions aren't so much considered a defense as trying to mitigate damage. A retraction has the potential to limit the amount of harm that is done to a plaintiff, and the hope is that there won't be further damage, actual damage to the reputation of the plaintiff, and then there won't have to be higher amounts of damages paid out by the defendant if the defendant is found liable. And then the last additional defense consideration is insurance. Media liability insurance is something to look into as a journalist. That can be expensive, so if you work for a news organization, you want to see that they pay for that. If you're a freelancer, shop around and see what pricing you can get on that. If you're being sued for libel and it's in a non-business capacity that you made the statements, you could try and make a claim against your homeowner's insurance and see if that will cover the damages. But that is for non-business statements. So if, as a journalist, you are being sued, you can't use your homeowner's insurance to cover that. So here is the map for the statute of limitations in libel actions. Color-coded. 1 year is in white, 2 years is in light orange, and then 3 years is in that rusty brown color. Depending on where you were reporting, depending on what state you're in, depending on what state a libel lawsuit is filed in, the different statute of limitations will apply. Too much time, you snooze, you lose. One last piece. I put together a table for you on different defenses that you could use in Ohio. So, substantial truth, opinion and fair comment, fair report privilege, CDA section 230, neutral reportage privilege, wire service defense, statute of limitations, and then anti-SLAPP. So I've got marked in the yes column defenses that you got available, the no column what isn't available. Wire service defense hasn't been used in Ohio. Ohio doesn't have anti-SLAPP laws, but does have the other defenses in place. That's addition to what we talked about with truth and opinion. I will make a printout of this for you for class, and also I will get the PowerPoint slides to you as well. All right, that wraps up Chapter 5.